Hi, my name is Karon Rowden. I'm with the Texas A&M Family and Veterans Advocacy Clinic. And today I'm here to talk to you about child support and some myths surrounding child support. First, a little bit about our program. We are an in-house law office within the law school, and we take a limited number of clients who are indigent and cannot afford to pay court costs. The students handle the client's cases from beginning to end under the direct supervision of an attorney like myself. All right, so let's go ahead and jump right in to the myths surrounding child support. All right, before we get to the myths, a little bit about what is child support. Generally the three areas of child support are regular child support that you are paid directly through the child support disbursement unit from the other parent to help support your child, or that you are paying to help support your child. Then there's also medical and dental support. So this is a little bit different. What this is if you don't carry health insurance for your child, and the other parent also doesn't, and neither of you have health insurance available at a reasonable cost, then the children could qualify for CHIPS or Medicaid. If either one of those are chosen, then the state has a right to come in and ask to be reimbursed for the cost of providing the insurance. So what happens is when you have a final order, the court will order child support, and then they will also order that you pay the medical and dental support to the Office of the Attorney General to help reimburse at least part of the cost for providing child support for your child or children. Now, there's other things that can be included as additional child support, but for this, we're going to keep it simple and just talk about regular child support, the one that everyone is familiar with. All right, so how is child support calculated? If you look at this chart, you'll see there's various numbers. And so where my mouse is right now, the little arrow, you'll see it says 0 to this side and 1 on the top. That means there's 0 other children that this person owes a duty of child support to, and there's 1 child before the court. That means that child support will generally, most likely, be set at 20% of the parent who is not the custodial parent. It'll be 20% of their income. And there's, as you can see from that chart, various different ways that child support can be affected. If there's more children that aren't part of this case, then the child support on this child would be lowered. And anyway, there's various different ways that child support is calculated. So if you do have a child support case, it's very important that you talk to an attorney so you know how the child support is going to be calculated, what can be used as income, etc. All right, so why is child support needed? Well, that's pretty obvious if you've ever raised a child. It is expensive to raise a child, to make sure and put a roof over their head, food on the table, clothes on their back, etc. All of those things are helped by offsetting the cost with payment of child support. All right, so this is where we start in the myths. Myth number 1, and this is a big one out there, that if I get joint custody 50-50, where each parent has the child or children 50% of the time, that neither parent is going to have to pay child support. Now, that can be the case. But sometimes one parent who makes a lot more money than the other parent might still be paying child support to the other parent to help maintain the children's standard of living in both homes, and also just to help support the child. So this would come into play if you have someone who might be ordered to pay $1,500 a month in child support, and the other person has been a stay-at-home parent the whole time, and maybe only makes minimum wage. And when they were married, there was income from both from just the primary caregiver. And now that they're separated, the wife or husband who stayed at home and took care of the children is only making minimum wage. The child support only would be like $200 if they were to pay the moneyed spouse. So the court might say, okay, we're going to take this $1,500 that this person should be paying for child support if it weren't 50-50, and we're going to take this $200 that this person should be paying if it weren't 50-50, and we're going to offset it so that this person is now only paying $1,300 for child support. All right. Myth number 2, child support is tax deductible. It is not tax deductible. So that's something you need to talk to your tax expert about. If you're wanting to help plan for your expenses, just understand that child support is not tax deductible. All right, number 3, child support is like welfare. The other parent gets money for nothing. Again, if you ever raised a child, you know that raising a child is very difficult. And as a non-custodial parent, the one who's paying the child support, you know that when the children are in your care also, that it takes a lot. You have to feed them, you have to bathe them or let them bathe themselves if they're old enough. You have to help them with homework. You have to take them to and from school, put clothes on their back, entertain them, etc. So helping out the other parent who has the children the majority of the time is not welfare. It is something to help your children, and therefore it should be something that you shouldn't be negative about and considering it welfare. Just consider it's your duty and you're helping your children. All right, myth number 4, child support always stops at age 18. No, this is also not true. If you have a child who is autistic and is going to need significant support throughout their adulthood, then there's a chance that child support is going to continue indefinitely. Myth number 5, child support payments can only be spent directly on the children. This would be nearly difficult, very difficult, if not impossible, to enforce by the courts. You can't say, okay, this amount of food that I'm providing for dinner is going directly to this child, and maybe I have children from another relationship, and so you have to make sure you're not commingling any of the food for the one child. Of course, direct expenses like clothes on the back, shoes on their feet, that would be easy to determine. But no, you don't only spend for direct expenses on the children. You spend on things like food, shelter, and extracurricular activities, which is, of course, a direct expense. But there's a lot of different expenses that go into raising a child. Next, myth number 6, I get to say how the other parent spends the child support money that I'm paying. And this goes along with the last slide. No, you do not get to say how the other parent spends the money. You can't direct them that they can only put it in a 529, that they can only spend it on the child, that they can't use it for any of their expenses. You just don't get that say. It is to benefit the child, and the other parent has the responsibility to spend the money to benefit the child. Myth number 7, only a parent can receive child support. No, this is not true. So this day and age, we have a lot of grandparents who are taking care of grandchildren, and we have a lot of just relative caregivers, maybe an aunt, an uncle, or an older sister or an older brother who's taking care of a younger brother or sister. And so when that happens, that person can receive child support. Myth number 8, I'm the mother of the child and I don't have to pay child support. So this could be I'm the mother or the father, but most often I have heard it expressed from a mother, and this generally might go back to the old notion that only women were the primary caregiver of their children. But no, this of course is not true. Both parents have a duty to support their children financially. Myth number 9, if I don't want to be involved in my child's life, then I don't have to pay child support. And this is definitely not true. It's unfortunate if you choose not to be involved in your child's life, but just because you make that choice does not mean that you are not under an obligation, under the law and morally, to help support your child. Myth number 10, if I quit my job and I get paid under the table, I won't have to pay child support. And this, again, is a big myth. So it may be more difficult for someone to find out how much you're being paid. And it also might be more difficult to get your pay garnished because you're working under the table. But if you don't make the payments, then you can go to jail when the other side or the Office of the Attorney General files an enforcement for non-payment of child support. Myth number 11, if I quit my job and I take a lower paying job, I can get my child support lowered. Well, generally this is not going to be the correct answer. Now there are some times when you really have no alternative but to take a lower paying job. But my question to people who say this is always, why would you want to cut off your nose to spite your face? So if you take a lower paying job just so that you do not have to pay child support, you're also hurting yourself in addition to hurting your child, because now you are going to have less money to pay on entertainment, on rent, on your car payment, car insurance, etc. So I've never quite understood this one, and it is a definite myth. If it can be shown that you should be making more money and that you intentionally quit your job in order to make less money and pay a lower child support payment, you can still be ordered to pay child support on the amount of the job that you quit. All right, myth number 12, only one parent is responsible for paying child support. So a lot of people think of this where we have a caregiver who's a grandparent or another relative, like the picture here. These grandparents are entitled to receive child support for raising this grandchild. If these people were really raising the grandchild, this is just a picture that I put on there. So if that happens, they are entitled to receive it from both parents, not just one. Both mom and dad will be ordered to pay child support. Even if mom and dad are still married and don't have custody of the children, they can both be ordered to pay child support for the children. Myth number 13, child support payments are more than enough to cover all expenses for a child, and I should not contribute any extra. Well, if you can't afford to, that's one thing. But if you can afford to, and you know that by not doing so, your children are no longer able to engage in extracurricular activities or live like they used to live when you and the other parent were together, perhaps you could reconsider that and think about the fact that maybe you're hurting your children if you're not providing one dime extra as a matter of principle. So that's myth number 13. You don't have to, unless you're court ordered to pay extracurricular activities or daycare expenses in addition to child support, but sometimes you may want to. Myth number 14, and there's going to be a couple of slides that kind of go over different variations of this particular issue. So my wife has custody and she's remarried and he makes a lot of money, so now I don't have to pay child support anymore, or at least my child support should be lowered. The new parent, the step parent that is involved in your child's life does not take your place, does not have the legal duty, unless they adopt the child, to pay child support for your child. You still have that obligation, both legally and morally. Myth number 15, I'm paying child support, so I get to claim the children on my tax return. This is not true. not unless you and the other parent agree. The other parent can allow you to. I generally recommend that my clients do not agree to let the other party claim all the children or the only child on their tax return, because the person on, we'll say, standard visitation schedule is having the child the majority of the time and is providing a significant amount of child support over the 20% that is being ordered by the other party if there's only one child. So therefore, I do believe that the primary caregiver is the one who should be claiming the child on their tax return. All right, myth number 16. My ex remarried and I can use his spouse's income to increase my child support. Okay, similar to the other side, that parent does not have a duty the step parent does not have a duty to support your child. Therefore, you cannot use the new spouse's income to help increase the child support that your former spouse owes you. All right, myth number 17. I have a premarital agreement, and this premarital agreement is a dowry that says that it's going to cover any future expenses if something happens and the marriage is dissolved. This is the set amount that I would have to pay. You cannot waive the child support, so it would not apply to child support, and you would still be ordered to pay child support if you are not the primary caregiver. Myth number 18, she isn't paying her child support, so I don't have to allow her to have her period of possession. Neither one is contingent on the other. So parent A can't say, I'm not letting him see the children because he hasn't paid child support. And parent B can't say, I'm not going to pay child support because she's not letting me see the child. Both parents should instead go back to court and get an enforcement, either an enforcement for non-payment of child support or an enforcement for not allowing the child to go see the other parent. That is your remedy. It is not to withhold either the payment of child support, nor is it your remedy to withhold visitation. Myth number 19, and we're almost done here. I can garnish my ex-spouse's new husband's pay for child support my ex-wife owes. Again, the other parent, the new step parent, does not have an obligation, and therefore you also cannot garnish that person's wages for payment of your ex-spouse's duty to provide child support. And finally, myth number 20. My ex says he's going to discharge his child support obligation by declaring bankruptcy. And this is also not possible. So you can always consult with a bankruptcy attorney and they can give you more details on how bankruptcy can affect division of marital property, for example. But child support is non-dischargeable, so that should not be something that you should have to worry about. So again, thank you very much for listening to my presentation. And if you have any questions regarding child support and you're needing legal assistance, you can always call the Tarrant County Bar Lawyer Referral Service or Tarrant County Legal Lines also. They answer legal questions on the second and fourth Thursday of each month. And if you're needing legal assistance, you can contact our office at 817-212-4123. Again, we take a very limited number of clients, and thank you for listening. Have a great day.